Okay, so in this part of my brief, my appellate brief, my appeal, I discussed the issue of whether the judge was wrong to say that the case has no merit. So basically, the judge basically said, look, I mean, your case is BS. You have no issue here. You have not been injured. And even if you have been injured and you don't know your origins, it happened a long time ago. And so I don't think that you have a case. It's just no basis to it. You have, basically go away. You have no issues. And for me, I found it to be, frankly, a little bit insensitive, to say the least, and just wrong. I mean, the fact that it happened a long time ago, I don't think is controlling. I think the bottom line is, no matter when it happened, it did happen, and I don't know my origins now, not a long time ago. The direct effect is now, right? And so I thought and still think that the judge was incredibly insensitive. I mean, and that's putting it nicely, to say that not only does my case lack merit, but that I haven't suffered an irreparable injury. So anyway, so in this part of the brief, I said the following. In her motion and in the pleadings, the plaintiff explained that she is likely to succeed on the merits because the case is a very simple premise that is grounded in both the state and federal constitutions. American citizens have a fundamental and constitutional right to know their origins. American citizens are also entitled to equal protection of the laws, as well as substantive and procedural due process. Fundamental rights cannot be taken away or withheld without a compelling justification. The district court determined in footnote 1 of its order denying the plaintiff's motion for a preliminary injunction that, quote, there are likely serious questions regarding whether a plaintiff can show a likelihood of success on the merits of her case, end quote. This is astonishing because the merits of the plaintiff's claims are crystal clear. But even assuming arguendo that the court ultimately decides that the plaintiff has not shown a likelihood of success on the merits, it cannot be seriously suggested that there are not serious questions to be explored about whether the plaintiff and people similarly situated to her have a fundamental right to know their origins. And if they do not have a fundamental, constitutional, and inalienable right to know their origins, like all other Americans, and for that matter, all other human beings on the planet, it cannot be seriously suggested that they do not have the right to know why not. And furthermore, the historical facts being what they are, it cannot be seriously suggested that there are not at least a couple of serious questions about why the defendants should not be held accountable. The district court erred by concluding that this case is unlikely to succeed on the merits. The arguments made by the undersigned in this case, including using the Foreign Sovereign Immunities Act to bring the powerful British government and monarchy before the courts of the United States to explain their commercial activities that continue to have direct effects in the United States after 400 years, are novel legal arguments, to be sure. It is true that no other lawyer has yet made these arguments on behalf of the millions of people in and from the Caribbean who have been injured by the commercial activities of these defendants. For example, moving for a $3 billion Mariva injunction to be placed on the $19 billion Crown estate of the British monarchy to pay for DNA tests for the children of wrongfully enslaved civilian people, or using the Foreign Sovereign Immunities Act to bring the British state before an American court for the atrocities that led to the loss of identity and data about the origins of these civilians has never been done. But it does not mean that these arguments are without merit. These arguments are indeed novel. The district court has expressed concerns about the merits of these arguments because of the novelty. However, the undersigned is convinced that there is at least a serious question that even people like the undersigned have a meritorious claim that they are entitled to the fundamental and constitutional right to know their origins like any other American. It is hard to believe that any court of law in the United States would disagree about the merits of such a basic constitutional argument. The Circuit Court should further note that there has been no actus interveniens between the defendant's wrongful actions that have led to the loss of identity and data of her antecedents, and the plaintiff's own loss of identity and data about her origins. It does not matter that the defendants ceased the commercial activities centuries ago. When the defendants ceased their commercial activities is not controlling in this case. What is controlling is the direct effect that these commercial activities continue to have on the aggrieved. The direct effect is that the ethnic origin of the aggrieved has been erased. The U.S. Constitution says that citizens of the United States have a fundamental constitutional right to know their origins. They are entitled to substantive and procedural due process before their fundamental rights are taken away. Thus, the court below erred both factually and legally in concluding that the undersigned is unlikely to succeed on the merits. For the foregoing reasons, de novo review is respectfully requested.